I'm concerned. I know that as soon as the SBI test results came out, everything about the SBI results were in the paper, and I'm concerned that anything I may put in this report, again, will be out there. I've got the DNA profiles of 46 players, and I don't feel it would be appropriate to place that out there. And he expressed his concerns on a number of occasions, and at some point, Mr. Nifong said, well, I know that, but at a minimum, I at least need the matches in that report. Not, let's leave any other evidence out. Let's leave the DNA. But at a minimum, you write the report you want, but what I need right now, at a minimum, is the matches. And I believe you'll hear that from, again, all of the witnesses who are presented. Not in any attempts to exclude anything and to keep things away from the defense, but as a way of protecting the privacy of the DNA profiles. What you will also hear from Dr. Meehan, is that on page 5 of his report, he talks about I have other non-probative evidence that I'm retaining in my office for other people who would like to see it. What I contend to you he's going to say on the witness stand is when he was talking about the non-probative evidence was when he was referring to the DNA that was found in the underwear and the one piece of DNA that was actually found on Ms. Mangum that was not identified. Not that Mr. Nifong asked him to write the report saying, please put that as non-probative, and I believe Dr. Meehan will state that perhaps was a poor choice of words on Dr. Meehan's part, but Dr. Meehan said according to industry standards that was sufficient to indicate he had other evidence out there that had not been identified for people looking in the report, and that they should know that. So this is, again, what I believe the evidence will be and presented, but there is no evidence, none, of any sort of agreement with Mr. Nifong and anybody to exclude evidence. And I would contend even the State Bar has become aware of that, because if you look at issue 10 on the issues that are contested, where if this was corresponding with what the complaint they had filed said, in the complaint they filed about an agreement between Dr. Meehan and Mr. Nifong, issue 10 no longer talks about an agreement between Mr. Nifong and Dr. Meehan. It said the defendant, by instructing Dr. Meehan to prepare a report containing positive matches, is where the language goes. It no longer goes to whether there was an agreement. It goes whether instructing him to do a report just to have positive matches, and I would contend to you, he even said less than that. He just said, at a minimum, this is what I mean. And both Dr. Meehan and Mr. Nifong will testify that this was an interim report, that discovery was an ongoing process, and this was not intended to be a final trial report. When Mr. Nifong got the report, he turned it over. At that point, something else you need to know about Mr. Nifong is that Mr. Nifong, before all the rules have changed about discovery, he had believed, I believe the testimony will show, that he had believed in open file discovery, that instead of sort of looking through the reports and seeing what should he turn over and what should he not turn over, he'd get a report, and without really reading it, for better or for worse, he'd turn it over to the defense. He'd always done it in the past because he wasn't trying to exclude anything he never had before. So he would not go through his reports to determine what should he give the defense and what he should not. He just always gave everything over, which he did in this case. Perhaps he should have been a little more aware at that point that he had not turned over. The report he'd gotten did not include the DNA that was located in the underwear and the one other piece of DNA on her. But he did not look, as he did not look at any of the other discovery, he pretty much just turned it over. One of the reasons, and I believe you'll hear this as well, is Dr. Meehan can tell very little about the DNA that we've heard about that's located, up to 4 males of DNA in the underwear and the one on her, other than at some point there was some male contact. It's extremely weak profile. That's why he listed it as non-probative evidence. It is an extremely weak profile. He said the 3 ways the DNA could have gotten there, or I contend to you, he'll say the 3 ways the DNA could have gotten there, was some minimal contact and some period of time. Doesn't know when. 2, whether it's very weak because of degradation, in terms of that it had been there for some period of time and had just become weak over a long period of time. Or number 3, and he said it's not likely, but number 3, some mishandling of the evidence. And because he could draw no conclusions from that DNA other than that it excluded the 3 lacrosse players who were charged, which we already knew they were excluded because all the DNA showed they were excluded from all the rape test kit, that he could draw no conclusions from that. Mr. Nifong, in hearing that, perhaps should have thought more of that evidence, but did not, because he didn't really see how, he did not understand. At this point, I believe he does have a better understanding